Hello, fellow law nerds. Welcome to a special reaction episode of Boom Lawyered, a Rewire News Group podcast hosted by the legal journalism team that is super jazzed that Democrats outperformed expectations. Woo! I'm Rewire News Group's editor at large, Imani Gandy.
And I'm Jess, Pieklo, Rewire News Group's executive editor. Rewire News Group is the one and only home for expert repro journalism that encourages you to enjoy some cautious optimism coming out of the midterms because, whoa. And the Boom Lawyer podcast is part of that mission. So big thanks to our subscribers. A welcome to our new listeners. Hey, viewers. What?
Hey! So exciting. So this morning, the Supreme Court heard oral arguments in another case that can best be described as a case about white grievance, right? That seems to be the theme this season, right, Jess?
Yeah, absolutely. I mean, let's see. We've already covered how white people are pretty mad that Black people can vote, right? White people are pretty upset about Black and brown folks potentially taking spots at Harvard and the University of North Carolina. But today, we may have the pinnacle case about white grievance before the Supreme Court so far, and that is Brackeen versus Haaland. And in this case, white folks are mad that they can't adopt Indigenous kids and sever their ties to their tribes and heritage, Imani.
Yeah, it's bad and ridiculous and gross and genocidal, and we're going to talk about why that is. So yes, SCOTUS heard oral arguments today in a case that's going to upend the Indian Child Welfare Act. Will likely upend the Indian Child Welfare Act because Gorsuch might be able to pull some people to his side, but we're going to get into that later as well. The statute is only 44 years old, which, we've talked about this. What is the deal with the 40-year itch when it comes to precedent, right? Yep. Roe, 40 years old. There was the Union case a few years, 40 years old. I mean, it just seems like every 40 years, we're just going to change the law. So the Indian Child Welfare Act was enacted in 1978 in response to a crisis affecting Native American children, families, and tribes, right? Journalist Rebecca Nagel, in her podcast, This Land, describes ICWA, as a set of guardrails intended to make sure that Native children sort of pass through the foster care and adoption process safely.
Right? We heard that in oral arguments when they were describing it as the gold standard for placements, for child placement statutes. Like that jumped out to me. Sorry, I didn't mean to interrupt.
Absolutely.
It was like, whoa.
It is the gold standard for child welfare in 23 states. I mean, it is an excellent law that prioritizes the safety and well-being of Native children. And according to the National Indian Child Welfare Association, studies have revealed that large numbers of Native children were being separated from their families, their extended families, and their communities by state child welfare and private adoption agencies. We're talking 25 to 35%, a quarter to a third of all Native children were removed from their families. And 85% of them were being placed outside of their families and communities, even when fit and willing relatives were available to adopt. Now, Nagel talks about this sort of the placement of children in white Christian evangelicals families as following on the heels of this mass removal of Indian children to boarding schools. I mean, we're talking Indian children were put on trains. They were sent to these boarding schools where their hair was cut. Right. That's the first. I mean, they say they did the same thing to enslaved Africans, right? Cut their hair, remove their ties to their culture. Right. And then their names would be changed to Christian names, white Christian names like, Mary and Joe and John. And the point of this was to reduce the number of Native children and in turn, the number of Native people. Right. And by reducing the number of children and Native people, you're reducing the number of tribes. You're killing tribal sovereignty. So let's talk about what this Brackeen case is about.
Brackeen fits into the theme of this term that we've been talking about so far, and we're only even like a month and a half in. It's wild, which is, a project, a whitening project, an erasing project. And what folks need to know about Brackeen in this case in particular is that it is a political campaign being exercised through the courts. And so let me explain what I mean by that. Brackeen is actually a collection of cases, right? It's an amalgamation of three cases, but the lead case is actually a challenge that was filed in the state of Texas in front of a judge we've talked about quite a bit on this podcast before, Judge Reed O'Connor. And he held that ICWA violates the U.S. Constitution. Just violates it. It's bad. It's bad. But let's break that down. So I said it's a political case. In oral arguments today, we heard the challengers talk about how at its core, this is a case about family law, right? Family law. Well, the challengers in this case had an entire battalion of legal representation behind them, advocacy organizations, pro bono law firms. Have you been involved in a family law dispute? This is highly unusual. This is not how they go. All right. It's also a facial challenge to ICWA, which is, saying straight up, this law is unconstitutional, as opposed to, hey, we were denied adoption in this process and have some grievances about how that process went. That would have been an applied challenge. All right. None of that matters to Reed O'Connor, who is a safe judge for conservatives. And he says ICWA is out. All right. I first reported on this case in 2018. That's how long conservatives have been at this. Reed O'Connor's decision is so unprecedented, the Fifth Circuit Court of Appeals doesn't even go along with it. They're like, what, sir? Are you the
uber liberal Fifth Circuit Court of Appeals, right?
is in Texas said no. No, the Fifth Circuit Court of Appeals, one of the most conservative federal appellate circuits in the country, they wouldn't even go along with O'Connor's nonsense. In fact, there's not a single federal court in the country that has ever declared ICWA unconstitutional. Even the Supreme Court has previously rejected arguments related to the constitutionality or similar statutes to ICWA. It's wild that we're here, but we are. And in fact, the Supreme Court's even rejected arguments that federal statutes generally related to Indigenous people, which was a big issue here, violate the Equal Protection Clause. And get this, Imani, we got to hear today about the Indian Commerce Clause.
Oh, Lord. Why are we so steeped in the Commerce Clause? I normally hate the Commerce Clause. Now we've been talking about the regular ass Commerce, the regular ass
Commerce Clause.
Your basic bitch Commerce Clause. And then we talked about the dormant Commerce Clause. Remember when we talked about the pig and the pork cases and whether or not Congress could regulate commerce when it wasn't regulating commerce, when it was just telling states to not screw up commerce. And now we're talking about the Indian Commerce Clause, which the Constitution grants Congress the authority to regulate the goings on, the affairs between Indian people and non-Indian people.
Mm-hmm.
And that's what this is, right? This is a case about the affairs between Indian people, between Native American people, and non-Native American people.
I just think the fact that we're talking about the Commerce Clause so much this term is payback for all the civil procedure we had to talk about last term that I was stuck with.
Fair enough.
All right. Okay, but so we should not be here. One of the themes of this Supreme Court term is that we should not be here. This is a cooked up political challenge, but the Supreme Court has stepped in. And so that's bad. Mm-hmm. And I guess we have to get into it. So, Imani,
yes,
we had some constitutional law at the court today. It was kind of sexy. What are the... I'm sorry, constitutional law is a little sexy. What are the big constitutional issues, though, in this case?
Well, Jess, let's talk about it. So the first one is something called the anti-commandeering rule. It's a principle that says that states are not required to sort of implement the rules and regulations that the federal government tells them to, right?
Okay.
Petitioners are claiming, the people challenging ICWA are claiming that only states have the power over child custody battles, mm-hmm. right? And even though that has never been the case for Indigenous children, right? This idea that the federal government cannot commandeer states to implement its rules regarding the affairs between Native Americans and non-Native Americans, it's always been the case that Congress can do that. And so claiming that Congress can't do that goes against pretty much every precedent imaginable, right? It goes mm-hmm. against legal precedent. It goes against the constitutional text itself. It goes against the original intent of the framers. If you want to start talking about originalism, and we're going to get into that because Justice Jackson is still riding the originalism train and she's doing it better than the quote unquote originalists themselves. what petitioners are asking goes against the existence of tribal sovereignty and the history of the relationship between colonizers, right, white Americans, and Native people. It's a basic case of originalism cutting in favor of what Congress has done and has been doing for nearly 2 centuries, and against essentially the claims of whiny white people who want to upend hundreds of years of precedent in order to get what they want. And what they want is Native kids.
I mean, in a nutshell, it's true. So we have like almost warring conservative arguments here. We have conservatives making a functionally states' rights argument that states have the right to dictate how and why and when they do family law proceedings like child placements, including for Native children, and also that it doesn't matter why ICWA came to be, because now it's harmful to both white folks and Native children, that it's actually harmful to keep Native kids with tribal relations.
Yeah.
I need a breath after that.
I know. It's first of all, it's just nonsense. It's nonsense. Congress has always had the authority to regulate all, quote, intercourse between Indians and not Indians. Stop smiling, because I'm not talking about sexual intercourse. This is not a podcast about Indians and non-Indians having sexual relationships. But when we talk about intercourse, we mean trade intercourse, right? Yeah. Commerce, just affairs, relations. And, we talked about the Dormant Commerce Clause a few weeks ago. Well, this is the Indian Commerce Clause. Congress has the power, plenary power. We heard a lot of talk about plenary power in arguments today. They have the full authority to regulate commerce, to regulate Indian affairs. And that specifically includes the power to protect Native children, right? And Texas and the Brackeens are arguing that ICWA intrudes on this traditionally state sphere, the sphere of family law, as you talked about. But when it comes to Indigenous children, I cannot stress this enough, that has always been in the federal sphere, always. So this is a matter of the Supremacy Clause. This is a matter of Congress arrogating to itself the power to regulate Indian affairs and superseding any contrary state laws. What's that? That's the Supremacy Clause. That's just straight Supremacy Clause. It has nothing to do with the 10th Amendment, and it has nothing to do with commandeering, because the federal government isn't asking the state to do anything. The federal government is saying, get out of the way. This is our purview.
And you really heard that when Texas was trying to make its case. And what came through for me is the reality that Texas just does not, the Solicitor General's office for the state of Texas just doesn't believe in tribal sovereignty. Like, it's just not a thing that like registers in the way that they understand it. Because if you consider the ways in which the federal government has historically treated its relationship with tribal nations, I mean, it makes sense, right? The white colonizing folks in the United States set up a system of governance that was relational to the folks who were already here to begin with.
Right.
Texas doesn't care.
No.
They're like, up from the ashes of, tribal lands comes the phoenix of the state of Oklahoma. Those were the kinds of arguments that they were making, that truly this evangelical project of whitening the country is the core, it's their core belief.
It is their core belief. And, I'm going to I'm going to mention Rebecca Nagel again, who has drawn the connections between what Texas is doing and the lawyers that have been hired in this case, right? One of the lawyers in this case is a guy named, I don't know if it's Mike McGill, Chad McGill, Brian McGill, I'm not sure, but he's a Gibson and Dunn like power attorney. Why is Gibson and Dunn representing the Brackeens in a family law case? Why? Because Gibson and Dunn represents big oil in Texas, huge oil companies. And what are we talking about here? All of the oil, something like $1.3 trillion, I read, worth of oil is located on tribal lands. So if they can figure out a way to undercut ICWA, then it undercuts tribal sovereignty altogether. And it allows white folks to come in and start grabbing oil, to start grabbing casinos, to start pushing people off of the lands that they negotiated with the United States government to live on, right? So that's a huge issue. But let's talk about the second big constitutional issue.
Okay.
which is whether or not the Brackeens, and that Chad, of course his name is Chad Brackeen, Chad and Julie Brackeen, they think that they're being discriminated against in violation of the Equal Protection Clause. Let's talk about that for a moment.
They're not?
Yeah, they're not. Next question.
I mean, we have to get into it because it was such a core component of the oral arguments. But listeners, viewers, they're not. Let me just rest assured that they're not. But here's the nugget of their argument. So petitioners are claiming a violation of the Equal Protection Clause by arguing that being quote unquote Indian is a racial classification rather than a political one. And this is really important. And Imani and I are going to walk through this because it's messy and it's a little complicated. So if petitioners win and being Indian for purposes of ICWA is a racial classification, then that means strict scrutiny applies. And listeners, viewers, we've talked about strict scrutiny a bunch on this podcast before. That is a constitutional standard of review that applies to things like racial classifications in the law, which is the argument here that the challengers are making. And there's a 5,000 pounds but hold up onto that statement. Congress can pass laws like ICWA, which gives preferences to Indigenous people because of Congress's unique authority under the Constitution to protect Native Americans and, as Imani was talking about, regulate the goings-on between Native Americans and non-Native Americans under the Indian Commerce Clause. So challengers just want to ignore that. They just want to straight up ignore the part of the Constitution that directly says what Congress can do in this case and say, no, it's actually unfair to white folks.
And from a group of people who normally like to dry hump the Constitution with such vigor that there's probably chafing involved, right? The fact that they just want to look at the Indian Commerce Clause and look at the provisions of the Constitution that talk about Indians being regulated as a separate sovereign, right? They talk about excluding 3/5 of people and Indians not fairly taxed. The Constitution specifically talks about Native American people. So for the quote unquote originalists on the court to be willing to ignore that because it doesn't comport with the whitening of America, right? With this white supremacist project that the Supreme Court is now spearheading in effect. It really demonstrates the lack of principles that are involved when you're talking about conservatives on the court, because originalism only works for them when originalism advances white supremacy. If in this case, when originalism pushes back against white supremacy, then suddenly originalism doesn't matter anymore. And it's really all about the feelings of white folks like the Brackeens who just want to adopt Native children, right?
Yeah, absolutely. And the thing is the Supreme Court has been very clear. There is a lot of precedent, which, listeners, viewers of this podcast, precedent schmecedent at this point. But there's so much precedent that says that when Congress legislates based on affiliation with federally recognized tribes, these are political classifications rather than racial. Political classifications. And it makes sense, again, if we go back to understanding how Congress was originally dealing with tribal nations, which was as sovereigns from the jump. Okay. Imani?
Yeah.
It gets even worse.
No.
It does.
Oh,
That's it gets even worse. Because I kind of hinted at this, but the challengers are arguing that ICWA actually hurts children. Okay. That not being exposed to whiteness is the real injury here. That not being ripped from tribal identity is not in the best interest of the children. Let me do that without the double negative. That it is in the best interest of Native children to be placed in white families as part of this experiment.
Yeah. Texas even wrote in their brief that the Equal Protection Clause applies here because Native American our children aren't learning.
But children's aren't learning. Oh,
Exactly.
Texas.
But Native American children are being harmed, prevented from being raised according to white middle-class standards. They actually argued that.
Yeah.
And that goes against everything Congress literally found in 1978, not even just in the legislative sessions and the hearings, but in the actual legislative findings of the statute, that Indian children are benefited, Native American children benefit when they either remain in their communities, are placed with extended family or communities, or placed in a related tribe, right? That it is not harmful to make white people wait a few placements down until there is no connection to their native history that can be found. Then they can be placed with white folks, but not before that, right? And so essentially, the through line, the bottom line is that the word Indian and the word Native, they're political classifications and always have been since the founding. Always have been. For purposes of Congress's constitutional authority, Indian and Native are not racial classifications. That's why the Constitution treats Indians, quote unquote, Indians differently, because the founders recognize them to be sovereign entities.
So is the Supreme Court.
Yes.
So has the Supreme Court. All right. And we heard a lot about this in arguments today, particularly a case called Morton versus Mancari. That's a 1974 case about a preference in hiring for the Bureau of Indian Affairs. And in that case, tribal members had a preference over other people to get jobs at BIA. And the Supreme Court said, that is completely legitimate. That is fine. It's not a violation of the Equal Protection Clause. Why? The classification is political, not racial.
Yeah, I mean, we really can't stress this enough, and that's because it's confusing, right? Like when you think about racial classifications, or when people are talking about BIPOC people, Black, Indigenous, people of color, that's a racial classification. But when you're talking about the status of Native Americans in relation to the United States government, it's a political classification because these classifications are based on their tribal membership, right? It's based on the citizenship in a sovereign nation. So the preference for placing Native children with Native people helps protect the Native child's status as a Native American, and that entitles them to certain benefits that non-Native American children, that children that don't have tribal affiliations, aren't entitled to, right? They're entitled to stuff like healthcare, employment preferences, housing. They're entitled to do things like pluck the feathers off of eagles, even though eagles are extinct, because that sort of ritual is inherent in their culture and was stripped from them when white people came over and just pillaged the place, let's say, right? So, just to make clear, Indian nations are called domestic dependent nations. That's wording that the Supreme Court used in a case from 1831. So this isn't like a new thing that the court decided in 1974. This goes back to days of old, days of yesteryear, if you will, right?
Yeah.
And the fact that these sovereigns pre-exist the United States, that's what governs the relationship between the United States and tribes. And actually, one of the lawyers used a very just kind of icky term, but talked about the federal subjugation of Indian tribes as sovereign states. And that really tells you about the level of colonization, settler colonialism that we're dealing with here, and the ways in which white folks are trying to undercut that because they want to assimilate Native children.
Yeah. Yeah. I mean, yes, Imani.
Yeah.
Yes.
It's bad.
But so let's talk about Mancari a little bit more, because under Mancari, the court said that the Constitution authorizes this kind of special legislation specifically for the quote unquote problems of Indians. And I hate that, but it is the language. We're stuck with it, which means that Congress gets to pass legislation that gives special treatment to Native Americans, and that legislation won't be subject to this really high constitutional standard because of this horrific relationship in history between the federal government and the sovereign nation states of Indian tribes. So it's just there. It's not even like
It's not a question.
Hey, is there an open question? Maybe a lot has changed in the political climate. No, this is an evangelical project come before the court.
And just to be clear, it wouldn't even make sense for strict scrutiny to apply to legislation related to, Indian commerce or the affairs of Indians if Indian and Native were viewed as a racial classification, because then every treaty, every piece of legislation, and Sonia Sotomayor and Elena Kagan were going back and talking about all of these treaties from way back in the day, they would all be presumptively invalid. And that just doesn't make sense. It cannot be that these legislation, these statutes, the relationship is presumptively invalid. So let's get into
but that's as radical as the argument that they wanted to make, right?
Yes.
Like, and they called them out on it. They're literally trying to argue that the historical relations and laws that have flown from that between the United States and tribal nations,
don't matter.
So
let's get into the oral arguments a bit, because your favorite pandemic beard haver, Neil Gorsuch, he's known to be good on Native American issues. He's from Colorado, Western states. There's a lot of history here. And he was good. He was raking the challengers' attorneys over the coals.
He was. Neil Gorsuch had a very good day, but he is a snake who cannot be trusted. And it doesn't matter that I like his beard or I want him to read me calm meditations at night. That voice is silky smooth. He may do some good in this case. He may stop the conservative majority, the FedSoc 6, from fully upending the Indian Child Welfare Act here because of all of those things, because he comes from a region that has a very different and understanding of tribal relations than, an academic exercise, for example, before the court. He has historically ruled in good ways here. And you saw that or you heard that in arguments today. And he was really boxing in the challengers here and explaining how radical their position was, and maybe bringing, Justice Kavanaugh along with him. I've got to say, every single time, though, he is introduced, Justice Kavanaugh, I expect him to come in with a belch.
Or like
what I hear. 100%. You hear Chief Justice John Roberts be like, and Justice Kavanaugh, and I'm like, it's like full on. Where's that? But Gorsuch had a good day. And if we end up with a fractured opinion that preserves some tribal sovereignty, I think that it will be a large part of his doing.
I think one of the things that struck me the most about Gorsuch's questioning and then Kavanaugh's questioning following up is this issue about whether or not Congress is permitted to regulate, quote, Indians just on their tribal lands, or whether they're able to regulate Indians off of their tribal lands.
Yes.
What the challenges were saying is that, sometimes these Native kids aren't even living on tribal lands. They don't necessarily have a connection to to any particular tribe. And so why is it that Congress can regulate the goings on of Indians everywhere, right? They should be limited to regulating the Indian affairs on reservations. And Gorsuch was like, what the hell, man? That doesn't even make any sense.
That's exactly what he said.
I mean, literally, he was just like, huh? And then specifically said that can't possibly make sense because there are landless tribes, right? There are tribes who have been removed from their land. They don't have any land, either because they weren't granted land or because they've been pushed off of their land, or for whatever reasons, or whether it's financial, economic, personal. But that doesn't mean just because they don't have 2 feet on the reservation that they're no longer Native American people. And Kavanaugh seemed to be on board for that argument. The last attorney who argued was a man named Gershenhorn. And he's from I think he's from Jenner and Block. So he's a big law attorney. He was really good at making these points. He made these points very clearly, much more clearly than the lawyer arguing for the DOJ did, right? But he made these points very clearly. And Kavanaugh, after he stopped like belching, seemed to be like, yeah, that kind of makes sense. So, I'll be interested to see if Gorsuch is able to bring Kavanaugh along and sort of generate this fractured opinion that, I think may actually happen.
Yeah. I know. I was surprised by that. And Gorsuch was very not interested in answering the equal protection argument also.
Oh, yeah.
So I just have no idea. And I mean, I my suspicion is he's not interested in answering the equal protection argument because of the absolute disaster that can open up for folks. And so he's looking for a way to, probably maintain some kind of sovereignty without giving, or with the ability to deliver some kind of conservative win. We saw that when we talked about the Bostock decision, right? I asked you, Imani, in our little Slack conversation while we were listening to arguments, is there a way that Gorsuch could Bostock this decision and give us something that feels good and is a win? I'm not going to not call Bostock. That's the case, for those of you who are new, that says Title VII protects LGBTQ employees from being fired if they're gay or trans. Gorsuch wrote that opinion. Could we get a similarly narrow decision that preserves ICWA in some capacity, but creates the potential for future fuckery? I think maybe. Yeah. So I got a question for you, Imani.
Yeah, hit me.
Are vaccines and babies the same thing?
I'm sorry, what now?
Are vaccines and babies the same thing?
I'm going to go with no.
Sam Alito seems to think they are.
Yeah, he really does. Sam Alito, God, for the love of God, bless his heart. So Sam Alito came in with a question about, well, because the discussion was about preferences, right?
Yes.
ICWA sets up a system by which there are preferences given to certain people, right? So the first preference is that the child is placed with their extended family. And the second preference is that the child is placed with just like a relative. And then the third preference, I believe, is that the child is placed in a Native American home, irrespective of whether or not that child is a member of the tribe that they are homed in.
Yeah.
And Sam Alito was talking about like whether or not placing children or like handing out children and providing preferences to Native American families would be the same as handing out COVID vaccines and providing preferences to Native Americans, right? His question was, would it be constitutional for Congress to say that we are going to give vaccines to Native Americans first? And if it isn't constitutional, why isn't it constitutional? He seems to think that vaccines and babies are similar. And in our Slack conversation, while the arguments were ongoing, you made the very good point that Sam Alito sees babies as commodities.
Yeah.
The way that he sees vaccines as commodities.
Yeah.
What the hell, man?
It's the reliable supply of domestic infants.
Yeah.
This is the Dobbs decision rearing its head in an ICWA case, right? Yeah. So we're talking about the Commerce Clause. What does the Commerce Clause regulate? Well, commerce, right? So healthcare is commerce. Our baby's commerce is basically what it came down to in that line of questioning. And John Roberts was apparently down for this. He loved this line of questioning and was willing to jump in and carry it along to say, well, basically, if we're going to say the federal government gets to make preferences for Native folks in whatever capacity they want to, why can't they say, well, you get COVID vaccines before, other folks, and then, what about that? And they were mad.
And they were mad. And the fact of the matter is, no, vaccines are not like babies. And the reason that Gershenhorn, the lawyer from Jenner and Block, who I was very, very impressed with, A, he was charming. B, he was one of the first white guy attorneys that I have watched or listened to in oral arguments who actually didn't try to barrel over the female justices when being questioned, right? Like he would start to interrupt them and then he would say, oh, I'm sorry, excuse me, Justice Sotomayor, please finish your question. And that's a rare thing to see from white male attorneys. So props to him for that. But, he made the point that when it comes to babies, if you're going to want to try and call babies commodities, when it comes to delivering babies or distributing babies, the issue with ICWA is that the classification is political, right?
Yes.
These babies have a political position in the tribe, and that political position entitles them to certain benefits. And that's why it is critical to ensure that they can maintain their status as citizens of a particular tribe so that they can access these benefits. That's not the same thing as vaccines, right?
No.
If you were to, if Congress were to pass a law saying we're going to give priority to Indians, just full stop, that would be giving priority to Indians, not as political entities, but to Indians qua Indians. And that's just like a Latin term to Indians as their status as Indians. That would be racial. And it kind of makes sense, right? I mentioned before, when you talk about brown and indigenous people of color, that's a racial classification. So if you were going to say, we're going to give BIPOC people vaccines, that would be racial, but that's not what's happening with these child placements. Children are being placed as political entities in order to maintain their status as citizens of this political entity. And I think that is critical.
Which, again, not to go back to my favorite pandemic beard, but here I am doing that, was the point that Justice Gorsuch actually was really great on, looking to, hey, the United States government does this in all sorts of other contexts, right? There's the Hague, when there are disputes, even in custody cases that involve independent sovereigns being the key there. The federal government is free to act.
Right. I mean, it doesn't make any sense otherwise, right? It doesn't. As I said, everything involving relationships between Native Americans and non-Native Americans would be presumptively invalid. And that cannot be, given the long history of oppression and genocide when it comes to this country and Native Americans.
It cannot be. But what a weird line of argument. And I haven't talked about Justice Barrett yet this podcast. This was where she was the most animated, in my opinion, too. And I honestly, I'm going to say, I expected to hear more from her in this argument, given her identity and during her confirmation hearings. Hey, Imani, did you know that Amy Coney Barrett is a mom?
Oh, God. Yeah. Did you know that she adopted some Black children? I heard that once.
Yeah. So, I remember covering her confirmation hearing, and all we heard was about the fact that she was a mom and that she was an adoptive mother and that this was, a core central part of her identity. And that didn't seem to carry through, which I was frankly a little surprised, but also relieved for, because it didn't need to. But she really got into this idea about, whether or not there is this, distribution of infants. And I just don't like it when she talks about any of that stuff.
No, it's not great. You know what else I don't like?
What?
Sam Alito, making fake, concern trolling about the fungibility of tribes, right? So there's this
What does that mean? Okay, what does fungibility mean?
Fungibility. So fungible means when one good can replace another, right? Money is fungible. Take a $5 bill, take a $10 bill, you replace one, it's no big deal. So the question becomes, when it comes to placement of children, right? This third category of placement, where you place a child with any Native American home before you place a child with some white Christian evangelicals. So Sam Alito brought up the point that that doesn't make sense to do that, because prior to white folks coming to this country and murdering a bunch of Native Americans, the Native American tribes were at war with each other. Yeah. So why would a Native American tribe based in Maine want to have any sort of relationship with tribal children based in Arizona? So are you saying that tribes are fungible and that it doesn't matter that the tribe in Maine is different from the tribe in Arizona? And the answer to that question is, don't be such a jackass, Sam. Honestly, stop being a jackass. First of all, clearly the point is that, maybe tribes were warring before white folks got here and decided to start murdering everyone. But shit has changed, Sam. And right now, Native American communities have been siphoned off, squirreled off into these particular areas and particular regions, purposefully so. Yeah. They were ripped apart. Tribal relationships between tribes were ripped apart. And so it doesn't make any sense in 2022 to be talking about warring tribes in 1750, whatever the fuck. It doesn't make any sense. And moreover, as I keep pronouncing his name different ways, but the Jenner and Block attorney, Gershengorn said essentially that is not happening. There is no case before the court where a tribe from Arizona just up and decided to pluck a Native child from Maine. Normally, what happens when you're placing children in a Native American home that is not their tribe, it's because these Native American children are living on different tribes than the tribe that they're from, or they're living on multiple tribal lands. And, maybe I don't want to I'm not going to name any nations because I don't have enough familiarity with them. But, Native American nation number 1 may want to adopt a child from Native American nation number 2 because of the relationship between those two tribes. Just because they don't have the same name doesn't mean they're not related. And specifically, when settler colonialism happened, I imagine disparate Native American tribes that maybe weren't friendly with each other before found themselves in a common cause. And that common cause was keeping the white man from either murdering them, taking their children, or forcing them off their land. So it was just such a disingenuous argument from such a disingenuous man who just, he grinds my gears.
And rightly so, but it sums up the evangelical project that is at the heart of this case, because even the Brackeens themselves, or one of the families, maybe not the Brackeens, one of the families involved absolutely sees their role as a foster and adoptive parent, as a white Christian foster and adoptive parent, as part of this mission, right? This is entrenched. I know we don't teach civics in this country anymore, but this whole idea of civilizing the savages is part of the evangelical project. Catherine Joyce has an entire book about this called The Child Catchers. Everybody go read that book because it's here and it's abroad. And Sam Alito basically was like, yeah, this is a thing that we believe, that white people come in and civilize these spaces. And one ways that they do that is by providing homes that are in the best interest of Native children.
And that means removing Native children from their communities. And one of the arguments that really, really angered me is when the attorney for the Brackeens, and by the way, it was the Brackeen. It is the Brackeens who see that the adopting and fostering as service to God. Julie Brackeen, before the Brackeen case even came about, when she adopted her first child, a 3-year-old, who then she returned to social services because it was too difficult for her. She just returned. And then she wanted a baby because it's easier to raise a baby from jump, right? So, but she said while she was struggling for the 5 months she had this 3-year-old, that she considered it a sacrifice, right? Because serving God is not supposed to be easy. It wasn't about the best interest of this child.
Nope.
It was about her interest in appeasing God in some way. So that's absolutely, the white Christian evangelical project is front and center in this case. But another argument that really made me angry was when the Brackeen's attorney said that removing Native children and placing them with white families won't affect tribal sovereignty one iota. That's what he said. It won't affect tribal sovereignty one iota. And listeners, viewers, let me tell you how genocide works, right?
I mean,
what you do when you're trying to remove a population is you remove their children, right? Because if you remove their children, if you remove Native children from their communities, if you strip them of their culture and you assimilate them into white evangelical spaces, then there are no more Native children. Like, they are still Native, but they're going to marry likely white people or non-Native people. And that is going to destroy tribal sovereignty. You can't have a tribe if you don't have any more members of that tribe. So it is absolutely unconscionable to be out here arguing that there is no effect that removing Native children from their tribes is going to have on tribal sovereignty. It's just ridiculous. You need kids to procreate. Why do you think they banned abortion?
I mean,
right?
What
are you talking about? Oy vey, I can't.
So I missed Solicitor General Preligar today.
Oh my God. Needler? I don't know who he is. Let's never put him in front of SCOTUS again when it comes to cases that are this critical to the rights of marginalized and oppressed people, because he was awful.
So the last live stream that Imani and I did was in response to the affirmative action challenges before the Supreme Court. And they just went completely so off the rails that we were here live streaming while they were still doing arguments because they just wouldn't stop talking about it. But one of the things in that live stream that we mentioned was how well Solicitor General Elizabeth Prelogar performed for the Biden administration in those cases. And she had an impossible job, which was basically to defend race-based affirmative action policies on the merits before 6 justices who were hell-bent on striking it. And she came in and understood that, yes, there was law that the court was supposed to be arguing, but she had a political mission to do, and she did it. I don't know that it'll change the outcome of the cases, but she did it. The attorney who was arguing on behalf of the Department of the Interior today walked in as though he was having a good faith argument on the merits of the law and absolutely got his ass handed to him by conservative justices who have no good faith.
Yeah, absolutely. Yeah, he walked in like it was the first day of torts class and he was being called on for the Socratic method. People who went to law school, you understand what I mean, right? Like you have just a back and forth about the actual facts and the law, and that's it, with no political agenda. Yeah. But clearly this is a political case. So you can't walk into the Supreme Court and think you're just going to argue the law and that's going to be it. And he was tripped up time and time again. His argument was, it was disjointed. It didn't make a lot of sense. It wasn't structured properly. It was not good. It was just night and day between Prelogar and this guy. And it really just tells a tale about, I don't know who decided or why it was decided that this guy was going to go. Maybe it's because he was with the Department of Interior, not the Department of, I don't know. But we need more Elizabeth Prelogars, and we need to push guys like Needler into the cornfield because he didn't do the Biden administration any favors.
Right. I mean, Justice Kegstan tripped him up.
Yeah. How are you going to let Justice Keg? That man is a stone cold dumbass. Like, I am sorry. It bothers me to no end that this jackass is on the Supreme Court. If you can't even hold your own in an argument with Justice Kegstan, with Brad McBeer, even my dog is upset about it. You can hear him in the background.
Truly.
It's truly absurd.
So it was, I will say, on the whole, today's arguments, kind of like the midterm election, went better than I anticipated, but I am still sort of like nervous in my innards about what is going to happen. And I'm not going to let the fact that Justice Gorsuch had such a good day or that he sounds so silky smooth lead me to believe that he's doing big good here. I don't think he is. But we're not going to know for a while because we probably won't get a decision until June.
Yeah, this is one of those June cases. And we have so many, as we talked about in the beginning of the show, and as we've been talking about all season, we have just 4 or 5 cases that are directly about the Supreme Court's mission to help conservatives install whiteness, to reinstall whiteness. And here's a comment that a thought that just occurred to me, right? You've got Tucker Carlson and white folks just all up in arms about great replacement theory, right?
Oh, yeah.
So they're all up in arms about white people being replaced by, black and brown people and anchor babies and yada, yada, yada. But somehow they can't wrap their minds around the fact that maybe Native children are being replaced by white people, right? Like the great replacement theory when it comes to Native children, they can't wrap their minds around that. They can't wrap their minds around Native children being removed from their culture and therefore having their culture be destroyed. Now, mind you, Indian culture and white culture, there's no such thing as white culture is racist culture. There may be Irish culture, Italian culture, whatever. There's no such thing as white culture besides fucking racism, and you're not going to convince me otherwise. But the point remains, the fact that they can't step outside of themselves and look at what they're arguing in relationship to another group of people, it's just stark to me. It's mind-boggling. That's not mind-boggling. It's actually pretty mind-unboggling. But the point is, it was a stark difference in the tenor of the arguments.
What a day.
What a day. What a day. And at least the arguments didn't go for 5 hours the way they did in the affirmative action cases. My God.
We had finished this live stream and they were still talking.
They were still talking. So thankfully that didn't happen today. No. But I know the midterms, It's the midterm aftermath. A lot of people weren't paying attention to this case.
Yeah.
So if you have any further questions, if you want to talk to us about any of this stuff, you can always find me on Twitter. I'm at Angry Black Lady. Jess is on Twitter at Hegemony, H to the E to the G to the E to the M to the O to the MMY. Yeah. Why? Because we love her.
Oh my God.
Also, you can and you should follow WeWire News Group. You should follow WeWire News Group. Rewire News Group on Twitter, on Instagram, and subscribe to our YouTube channel. That way you can get a notification whenever our podcasts get uploaded or whenever we're about to go live. We're so excited to be live this season, to be on video, so
It's
you can
awesome.
look at our faces. But if you don't want to look at our faces today, we get it. We ain't mad at you. We get it. You can listen to us wherever you get your podcasts normally.
Absolutely. Absolutely.
Google Play,
And
Apple Podcasts, Overcast, Spotify, wherever. Macy's.
Wherever you
I don't know.
podcast at Macy's?
Yeah, I don't know. Who knows?
And I know, like, this case being argued the day after the midterm elections, everybody's talking about the elections. It was a big night for folks who are fans of abortion rights and access. And so Imani and I are absolutely going to be talking about what all of that means in our next episode. But we wanted to make sure that this case got the attention that it deserved, because it is one of the most monumentous cases before the court this term, and barely anybody's talking about it.
And it has huge implications that go beyond family law. I mean, we're
Mhm.
talking about the literal destruction of tribal sovereignty as it's been in place for centuries. And that should concern everyone.
I think I need to get a drink now.
I think I do too. So let's go get those drinks. And what are we going to do?
We'll see you on the tubes, folks.
See you on the tubes and the YouTubes.
And the YouTubes. Thanks for joining.
Yay, thank you.